Let me be very clear about what we are analyzing today. This is not politics. This is not ideology. This is a bank fraud case. And every serious white-collar fraud case begins the same way, with a signature on a loan application. Before you dismiss this as just another headline, I want you to understand what prosecutors actually look at when they build a case like this. They don't start with opinions, they start with documents. And the most important document in this entire case is something called a net worth schedule. That spreadsheet is the smoking gun. You've been told that the banks were happy. You've been told that everyone made money, so there was no crime. That story collapses the moment you look at the internal risk reports, because those reports show the banks relied on these numbers, and they relied on numbers that were false. I'm holding the document that changes everything, a signed statement of financial condition certified by the defendant. On page 4, it lists the value of his personal apartment at $327 million. But sitting right next to that number is the bank's own appraisal from the same year, valuing that apartment at under $30 million. That is a $300 million gap on a single line item. In federal fraud cases, a zero is never just a zero. When you add a zero to a financial statement, it stops being a mistake and becomes a felony. The defense calls it an error, the law calls it fraud, and the consequences here are not theoretical. They include a permanent ban from doing business in New York, the forced sale of flagship properties, and a cash penalty that could exceed $370 million. Let's walk through how the fraud actually worked. Start with the Trump Tower triplex. For years, the financial statements claimed this apartment was 30,000 square feet. Based on that size, they applied a premium price per square foot, making it on paper the most expensive apartment in New York City history. There was just one problem. The apartment is 10,196 square feet. This is not a rounding error. This is not a judgment call. This is claiming a property is 3 times larger than it physically is. You know how big your own home is. You live in it. When you triple its size on a sworn legal document, you are doing it for one reason: leverage. That single lie inflated net worth by roughly $300 million that existed only on paper, but was used to secure real loans. And this wasn't an isolated incident. Take 40 Wall Street. Bank appraisers valued it at about $200 million. The defendant listed it at $525 million. How did they get there? They manipulated the capitalization rate, the expected rate of return, changed that assumption, and the valuation explodes. Internal emails show they treated a risky aging building like a pristine Class A skyscraper. Same pattern, same result. Then there's Seven Springs Estate. To the tax authorities, it was a protected conservation property, lowering taxes. To the banks, it was a prime development site worth $291 million. You don't get to tell two different truths depending on who's asking. That's fraud, and the judge already ruled on these facts. This case didn't even need a jury to decide liability. The evidence was so overwhelming that the court issued summary judgment, meaning the documents spoke for themselves. The square footage was false. The valuations were fabricated. Fraud was established as a matter of law. The only question left is the penalty. Now let's address the defense's favorite argument. He relied on his accountants. That defense collapses under the evidence. What the testimony revealed was result-oriented valuation, a process where you start with the number you want and work backward to justify it. Handwritten notes show executives targeting a specific net worth. We need to hit 4 billion shares, and then inflating assets until the spreadsheet reached that number. That's not accounting. That's fabrication. The former CFO testified that the defendant personally reviewed these statements. If the number was too low, he sent them back. He wasn't passive. He was setting the target. The disclaimer argument failed too. You don't get to commit fraud and then hide behind fine print. When you sign a financial statement, you certify it's accurate to the best of your knowledge. And the evidence shows the defendant knew exactly what he was signing. Now let's deal with the biggest myth in this case. No one was hurt. That's legally wrong. By inflating his net worth, the defendant qualified for elite borrower rates, paying billionaire interest instead of standard commercial rates. Experts calculated the difference, over $160 million in saved interest. That's money that stayed in his pocket through deception. And the real victim? Every honest developer. When one borrower lies and gets cheaper money, he can outbid competitors who tell the truth. Fraud becomes a competitive advantage. Integrity becomes a liability. That distorts the entire market. Now look at the penalties. The state is seeking disgorgement, forcing the defendant to give back every dollar gained through fraud. That includes interest savings, property sale profits, and prejudgment interest. The total ranges between $350 and $400 million. But money isn't the biggest threat. Control is. The court is considering a permanent ban on serving as an officer or director of any New York company. Business certificates could be revoked. A receiver could be appointed to sell assets. That's the corporate death penalty, and it's already begun. An independent monitor, retired Judge Barbara Jones, is now embedded inside the organization. She reviews every transaction. Her reports have flagged undisclosed transfers, suspicious loans, and ongoing compliance failures. Monitors are used for mob cases and massive corruption scandals. Installing one inside a former president's business is unprecedented. It signals one thing: the court does not trust this defendant. This isn't about politics. Square footage doesn't vote. Interest rates don't campaign. Spreadsheets don't lie. Math is the great equalizer. You can attack judges, you can bully witnesses, but you can't intimidate a spreadsheet. This case is about whether the law applies equally, even at the highest levels of power. The facts are fixed, the fraud is proven, the final judgment is coming, and when it does, I'll be here and breaking it down page by page. Evidence, not spin. If you believe rules should apply to everyone, subscribe and tell me this in the comments. Do you see this as the end of the business empire or just another escape? I read every response. I'll see you in the next analysis.